Oh, good morning, good morning, good morning,
Good
everybody.
morning.
Today is a very different type of day. A Texas death row inmate, his name is James Broadnax, has a 6 p.m. Central Standard Time appointment with lethal injection. That is why I wanted to talk about this case today. Mr. Broadnax explains I was, what is that noise? I was not the shooter, right? Okay, well, we know what Texas law says. If you're there and somebody dies, you get the same charge as the person who pulled the trigger, whatever. So, but you got to stop and think, is that fair? Is it not fair? I'm not sure. I've always been a proponent of the death penalty. I will be honest about that. But let me show you something here. I made this today. All right. So I made a little poll so people can answer the questions for themselves. And should all parties in a crime get the same punishment? Yes, no, or it depends on the type of crime. That is one of the things that I think people. Oh, look, why is it right there? Oh, I don't know if I can move that. Oh, it looks too big. Uh, okay, let me see if I can fix this so we can both see ourselves. Okay, no, we're not with my thing right there. Okay, well, all right, we'll just leave it like that. Anyway, so that is the question. That is what we're going to talk about today. But first, we're going to talk about the appeal process. I'm hearing a lot of damn noise. What is that? Hope it's not my phone. Um, in the appeals process, he tried to go through the normal steps to the Texas Court of Criminal Appeals. Well, they denied, so it gets kicked up to the United States Supreme Court. So we're going to read the United States Supreme Court document first. Well, no, I think. Whoops! Don't fall out because I can't see you. Hang on a minute. Just stage. There you go. Oh, good. Now there you are. Okay. So first thing
Yeah,
we're going to do. Go ahead.
I was just having problems with my headphones. It like all of a sudden I got this screeching noise and then they
Yeah.
disconnected. I don't know what happened.
I was like, oh God, I'm here. I know I was hearing something weird. I was like, what is that?
Yeah, I don't know what happened. It like screeched. It was horrible. And then they were like disconnected, but they were showing connected, but I couldn't hear you. It was just so I just popped out, popped back in.
So the first thing, okay, first I'm going to talk about what he actually did. We'll do it in that order. And then we're going to read his appeal. And then we're going to watch a little video from he has his own, called the Save James Broadnax Foundation or group. It's one of those anyway. And so they have this site, and they have a site on YouTube. And so he's the one talking that we're going to watch as far as the video goes. But let's just talk about the news at first. So here we go. I'm going to read a little story about how this all started. Now, a North Texas man who claims he was not the shooter in a fatal robbery that killed two people nearly 18 years ago, and who says prosecutors misused his rap lyrics that he wrote to secure his death sentence, faced execution Thursday morning. James Broadnax was sentenced to death for the 2008 shooting deaths of two men outside a suburban Dallas music studio. Prosecutors say that Broadnax and his cousin, Demarius Cummings, fatally shot and robbed Stephen Swan and Matthew Butler in a parking lot. It was Butler's recording studio in Garland. Cummings was sentenced to life without parole. Prosecutors say that Broadnax, 37, confessed to the shootings, telling reporters during jailhouse interviews that I pulled the trigger and that he had no remorse. Broadnax was scheduled to receive a lethal injection after 6 p.m. at the state penitentiary in Huntsville, about 70 miles north of Houston. His attorney has asked the U.S. Supreme Court to stay his execution, filing multiple final appeals after lower courts declined to stop the lethal injection. His lawyers have focused his final appeals on two issues. Cummings recently confessed to being the shooter, and Broadnax's constitutional rights were violated because prosecutors eliminated potential jurors during his trial on the basis of race. Okay, now, um, we know that they always claim that their rights were violated. Every single appeal is going to have their rights are violated. But he says, I'm really going to tell it like it's supposed to be told, that it was me. This is Cummings talking, that I was the killer. I shot Matthew Bullard, Stephen Swan. Cummings says this recently from prison in a video created as part of the efforts to stop Broadnax's execution. Broadnax's attorneys say in filings with the high courts that Cummings' confession is corroborated by the fact that his DNA, and not Mr. Broadnax's, was found on the murder weapon and in the pocket of one of the victims. Okay. In the video, Broadnax says that his confession was false, and at the time he didn't care about his life. Broadnax's lawyers say he was under the influence of drugs during this television interview. He also apologized to the families of Butler and Swan for taking part in the robbery. I wished I could show them my soul, he says, so they could see just how sorry I am, and I'm very much remorseful for everything that's happened. This is Broadnax talking. His attorneys also allege that prosecutors dismissed all 7 potential black jurors on the basis of their race, utilizing a spreadsheet during the jury selection that bolded the names of every black juror, according to court documents. One black juror was later reinstated to the jury, and Broadnax is black. Now, I don't like the fact that they're trying to bring that in, but you hear this repeatedly all the times when you see appeals. They will use everything, every single thing they can as a reason to get an appeal. So now, Broadnax's attorneys had argued earlier that they had violated his constitutional rights by using some of the rap lyrics he wrote to portray him as a violent and dangerous person to secure a death sentence. Several A-list rappers, including Travis Scott, T.I., and Killer Mike, had filed briefs at the Supreme Court in support of Broadnax's appeal. So he has a lot of high people saying, no, that's not right. This is not what happened. You can't take the words from our music and make the decision that that's part of the reason why we killed anybody, right? So both the high courts rejected the appeals as well as another that focused on how forensic evidence was presented at the trial. The Texas Board of Pardons and Paroles on Tuesday denied Broadnax's request for a 180-day reprieve or to commute his death sentence. The Texas Attorney General's office has described Cummings' confession as the shooter's questionable new evidence. It's also said in the court documents that Broadnax claims the potential black jurors were targeted for removal is entirely meritless, as these jurors were stricken not because of race, but because of their answers during the questioning, including that some opposed the death penalty. Teresa Butler, Matthew Butler's mother, has asked that the execution proceed. Wow. Okay. So this is called confession from Cummings. The so-called confession from Cummings is just a stall tactic by Broadnax's desperate defense team. It's all a lie. But Butler wrote in a post on social media. This is the mother of Mr. Butler wrote that in a post on social media. If the execution is carried out, Broadnax would be the 3rd person put to death this year in Texas, which has historically held more executions than any other state. About an hour before Broadnax's scheduled execution on Thursday, Florida is set to put to death James Ernest Hitchcock, who is 70 years old, for beating and choking his 13-year-old step niece. Wow. Okay, so now let's go over, and we're going to go over and read his actual appeal that's right here. So anyway, let me say hello, and we appreciate everybody coming in today. If you get a chance, please go ahead and do a vote on our on our little questionnaire there. But let me do this first. I need to first go over and read. Let me pull it up real quick. Oh boy. And I'm going to tell y'all this. It's raining like hell where I'm at. We're having lightning and all that. So if our feed just zaps, it'll be because our electricity went out, etc. So just bear with us if that happens. Okay. So let me pull up my fair use disclosure so we can get that on out of here and get it taken care of. Whoops. Hope everybody's having a wonderful day. Here we go. All right. Oh, there we go. No, just put it up, please. What in the hell is this thing doing? No, I don't need that. All right. Boy, every time you need something in a hurry, look what happens.
I know.
I'm telling you, it's crazy. What are you doing? Well, it doesn't want to pull it back up today. I don't know why, but all right. Here we go. Maybe it'll be over here. Let's see if I can find it over here in this one. Well, we might just go ahead and start reading. I'll just, once it pulls up, I'll read it in a little bit because, it's just important that we do that. But here we go. Got it. All right. There we go. Come on. I believe in full transparency and want to and clearly disclose any material facts that could influence somebody's decision on the. Okay, what is that? That is not mine. That is not mine. That is somebody else's. Damn it. Okay. Well, I'm like, it's asking about investors. I don't have any investors. What are you talking about? Crazy. Oh my. All right, here we go. This content is created under the principles of fair use as defined in Section 107 of the U.S. Copyright Act. All videos, images, audio clips, and excerpts used in this content are for purposes of criticism, commentary, news reporting, teaching, scholarships, and research. I transform original materials by adding an analysis, legal commentary, opinion, and educational context, which gives the content new meaning and purpose. This is non-substantive and does not compete with or diminish the value of the original works. There is no copyright infringement intended. All rights remain the original owners. Content is used in a limited and transformative manner. If you are a copyright owner and believe your material has been used in any way that does not comply with fair use, please contact me directly so we can resolve this issue promptly. There you go. Now, so let's go ahead and we're going to start reading this, his appeal to the U.S. Supreme Court. I'm not going to go through the first pages because, as you'll see, this is just the coverlet or the cover, and then it talks about the table of contents, etc. So we're going to get on down here to where the real meat starts, right here. To the Honorable Samuel Alito, Associate Justice of the Supreme Court of the United States and Circuit Justice for the Fifth Circuit. The state of Texas has scheduled the execution of James Garfield Broadnax for April the 30th, 2026, pursuant to 28 U.S.C. 2101F. And Supreme Court Rule Number 23. Mr. Broadnax respectfully requests a stay of execution pending consideration and disposition of the petition for writ of certiorari filed along with his application. Here's his introduction. Mr. James Broadnax has been on Texas death row since 2009 and now faces imminent execution on April 30th, 2026, unless this court grants a stay of execution. This court should grant a stay because new evidence undercuts the basis for Mr. Broadnax's conviction and capital sentence, and because his trial was plagued by violations of his 8th and 14th Amendment rights. First, Mr. Broadnax was convicted and sentenced to death for the murder of 2 victims on the theory that Mr. Broadnax was the individual who shot the victims. New evidence in the form of declarations under penalty of perjury from Broadnax's co-defendant, Mr. Demarius Cummings, confirms that Mr. Cummings, not Mr. Broadnax, was the actual shooter of these victims. This new evidence establishes multiple constitutional violations of Mr. Broadnax's 8th and 14th Amendment rights, as no jury or court has evaluated whether, in light of the actual facts of the crime, he was sufficiently culpable to be sentenced to death or whether his sentence was disproportionate and unfair. Second, Mr. Broadnax, a black defendant, was convicted by a nearly all-white jury after trial replete with racially charged statements and arguments by the Dallas County District Attorney's Office. New evidence from Mr. Cummings' trial confirms that the state sorted prospective jurors and based on their race and relied on their racial classifications to strike black juries in violation of Mr. Broadnax's Batson rights, and then lied about it. Here is the background. In 2008, Mr. Broadnax and Demarius Cummings were arrested for the murder of 2 victims during the course of a botched robbery. The case was severed, which means instead of trying them together, they let them split, which is kind of what to expect in most cases when you have 2 defendants. They very rarely try them together because it's considered to be not really fair to each one individually. So the state prosecuted Mr. Broadnax and secured the death sentence on the theory that Mr. Broadnax shot the victims and prosecuted Mr. Cummings as just a participant in the crime. The state did not seek the death penalty against Mr. Cummings, and Mr. Cummings was sentenced to life without parole. The central evidence in the state's case against Mr. Broadnax were statements made by Mr. Broadnax and Mr. Cummings to the media following their arrest, where both defendants identified Mr. Broadnax as the shooter. However, the other evidence in both trials pointed to Mr. Cummings being the shooter, as only Mr. Cummings' DNA was found on the murder weapon and in the pocket of one of the victims, whereas Mr. Broadnax's DNA was not identified on these items. Mr. Broadnax's statement to the media confessing that he was the shooter were also inherently unreliable, as he was under the influence of the drugs at the time of the offense and could not reliably recount the events of that evening. and displayed signs of severe psychological distress and suicidal tendencies at the time of the interview. Following the trial, Judge's December 17, 2025 order setting an execution date, Mr. Broadnax's counsel met with Mr. Cummings, as he had done several times over the past 10 years. Mr. Cummings had always maintained that Mr. Broadnax was the shooter, but during the February 2026 meeting with Mr. Broadnax's counsel, Mr. Cummings admitted for the first time that he was in fact the shooter of the two victims and that Mr. Broadnax falsely took the blame for being the shooter to protect him. Mr. Cummings executed a declaration under penalty of perjury stating this: "It was my idea to rob Mr. Swan and Mr. Butler. I obtained the pistol. We took it with us that evening and which was used to shoot the victims. Following the crime, James and I spoke about the story we were going to tell. I persuaded James to take the blame for the shooting of the two victims. Later, we both gave statements to the media. In James's statements, he said that he had participated in the robberies and shot the two victims, while my statements, I said that while I had participated in the robberies, James had shot the two victims. These statements were not accurate. In fact, I was the one who shot the two victims, not James." The third subsequent appellate, and here's ex parte for Mr. Broadnax. We're not going to go through all the numbers. The reliability of Mr. Cummings' declaration is underscored by the other evidence presented at Mr. Broadnax's trial, including DNA evidence linking Mr. Cummings and not Mr. Broadnax to the murder weapon and clothing of one of the victims. Mr. Cummings described why he did not reveal this information previously. "I have always maintained that James was the one who shot Mr. Swan and Mr. Butler. But the fact that James received a death sentence for these crimes while I was the one who shot the victims has been weighing on my conscience, particularly as I have become more spiritual during my years in prison. When Broadnax's counsel told me on February the 20th that James was scheduled to be executed on April 30th, I decided it was my time to come clean." Now I'm going to stop for a minute and I'm going to say this. And I'm not saying this to be mean, I'm not. But have y'all ever noticed that God lives in prison? As soon as these people end up in prison, what is the first thing they start clinging to? The Bible and God, or some type of religious beliefs. They become religious all of a sudden. Now, I realize there's not a lot to do in prison, and I realize that in order to get along with some groups in prison, you need to be involved in a religious what's the word I want to use here? In some religious group, because there are a lot of different religious groups in prison. So here you go. We'll keep reading. During his trial, Mr. Broadnax was convicted by a nearly all-white jury after the state systematically struck every qualified black prospective juror. The trial judge declined to engage in the required Batson analysis during Batson hearing, expressing that there was a problem with the whole line of Batson cases for implying some sort of nefarious intent on the part of the prosecutors. Now, I'm going to look this up for you guys because we need to understand what the Batson is, okay? So let's take a look. Batson. Okay. Okay, here we go. I wanted to, okay, wow, come on now. The Batson challenge is, here we go. A Batson challenge is a legal objection raised during a jury selection, arguing that the opposing party is using preemptory challenges to exclude potential jurors solely on the basis of race, ethnicity, or sex. It protects against discriminatory jury selection, ensuring equal protection. That is what they're saying. So, and he goes on down, he says, the trial judge reinstated a single black juror because of the fact that there are no African American jurors on this jury, and there was a disproportionate number of African American jurors who were struck. Years later, the state disclosed for the first time a spreadsheet used during voir dire, which marked the race and gender of each prospective juror. The names of every single black juror, and only the black jurors, was bolded. In light of this new evidence, Mr. Broadnax filed an amended federal habeas petition. Okay, so there's his petition, Broadnax versus Davis, and then there's the numbers. In response, the state claimed that the spreadsheet was created in preparation for a Batson hearing held after the jury had been selected. Okay, so I'm not going to read all those numbers. We'll be here all day. In denying relief of the Fifth Circuit explicitly relied on the state's assertion that it created the spreadsheet when preparing to defend its use of peremptory challenges, Broadnax versus Lumpkin. In January of 2025, the Dallas County District Attorney's Office allowed counsel for Mr. Broadnax to review for the first time its jury selection files from the separate trial of Mr. Broadnax's co-defendant. Mr. Cummings was tried, convicted, and sentenced to life without parole for his involvement in the same incidents underlying Mr. Broadnax's conviction. The newly available documents for Mr. Cummings' case included a chart of prospective jurors prepared by the same team of attorneys representing the state as in Mr. Broadnax's case, with the same notation used to track the race and gender of the prospective jurors. However, in Mr. Cummings' case, there were no Batson objections and the state had no need to prepare for Batson hearings. In other words, the newly disclosed chart confirmed that the state tracked jurors by race and gender during jury selection as part of their usual systematic voir dire practices, not in preparation for a particular Batson hearing, as the state previously asserted. Okay, so this is looking kind of bad. On March 18th of 2026, Mr. Broadnax filed a third subsequent habeas corpus application with the Texas Court of Criminal Appeals, seeking relief pursuant to his 8th and 14th Amendments based on the newly issued declaration from Mr. Cummings. The newly disclosed jury chart from Mr. Cummings' trial and new juror affidavits from several of the excluded black jurors in Mr. Broadnax's case. On April the 7th, 2026, the court denied Mr. Broadnax's petition. The court's review of Mr. Broadnax's claims and a stay of his execution during the pendency of such review is necessary to present the carrying out of the death sentences that was secured in violation of Mr. Broadnax's 8th and 14th Amendment rights. Here's the standards for stay of execution. The standards for granting a stay of execution is well established. The party seeking a stay must establish that he is likely to succeed on the merits, that he is likely to suffer irreparable harm in the absence of preliminary relief, that the balance of equities tips in his favor, and that an injunction in the public interest, this is Ramirez versus Collier, discusses that. In a death penalty case, this court has the equitable power to order a stay in order to resolve the merits of the petitioner's claim before the scheduled date of execution. To permit during consideration of the merits, Barefoot, and there's a whole, here's his citations. All of these factors weigh in favor of staying Mr. Broadnax's execution, pending this court's resolution of his petition for writ of certiorari concurrently filed with this application. This court should grant a stay of execution. Number one, petition is likely to succeed on the merits. In the context of an application for stay of execution, pending the court's consideration of his writ of certiorari, a likelihood of success on the merits means that there's reasonable probability that 4 members of the court would consider the underlying issue sufficiently meritorious for the grant of certiorari, and there is a significant possibility of reversal in the lower court's decision. Mr. Broadnax's claims for relief meet this standard. Mr. Broadnax's 8th and 14th Amendment claims are likely to succeed on merits. Mr. Broadnax's 8th Amendment claim warrants a review, as the new declaration form of Mr. Cummings wholly undermines the theory on which Mr. Broadnax was convicted of capital murder. As for Mr. Broadnax was prosecuted, convicted, and sentenced to death in the mistaken premise that he's acted as the triggerman. Wow. The court's holdings demonstrates that the death penalty is disproportionate under the 8th Amendment for the non-shooter under these facts. While the state generally has wide discretion in deciding how much retribution to exact in a given case, the death penalty, unique in its own severity and irrevocably, requires that the state inquire into the relevant facts of the character and record of the individual offenders. This means that the focus had to be on the defendant's culpability, and we insist on individualized considerations as constitutional requirements in imposing the death sentence. In particular, and critically for the purpose of this case, the death penalty is not proportionate under the 8th Amendment for the non-killer defendants unless an examination shows the defendant's own conduct and state of mind his own conduct and state of mind warrant imposition of the death penalty by distinguishing him as the most culpable and dangerous of the murderers. Does that make a lot of sense? The most culpable and dangerous of the murderers. Okay. The state's case for establishing that Mr. Broadnax should be sentenced to death and that it constituted a continuing threat to society was primarily based on the theory that Mr. Broadnax shot the 2 victims and in a manner in which he allegedly did so. Mr. Cummings' confessions undermines his theory, and the jury was never presented with the question of whether Mr. Broadnax's conduct as non-trigger man and his state of mind warranted imposition of the death penalty. Mr. Broadnax's punishment to be limited to his um, participation in the underlying felony and tailored his personal responsibility and moral guilt. The death penalty is disproportionate here in light of Mr. Cummings' confession because, as it indicates that Mr. Broadnax did not suggest the robbery, obtain the murder weapon, or actually shoot the two victims. Well, doesn't this sound like Gypsy Rose Blanchard and Nick Godejohn? Wow. Okay. Mr. Broadnax claims, based on this new evidence, carries a reasonable probability that four members of the court would consider the underlying issue sufficiently meritorious for the grant of satori, and there is significant possibility of reversal of the lower court's decision. Mr. Broadnax's Batson claim is likely to proceed into the merits. Mr. Broadnax's Batson claim warrants review, especially in light of the new evidence confirming that the state's systematic race-based jury selection practices. For more than a century, this court consistently and repeatedly has reaffirmed that racial discrimination by the states in jury selection offends the Equal Protection Clause. I'm going to agree with that. I'm going to agree with it right there. Now, I have to read all that. Here the state struck all 7 black qualified jurors based upon race. Put differently, the state used its preparatory strikes on just 18% of the white jurors, but 100% of the black jurors. Okay. And over here it says, finding a Batson violation where the state struck 91% of the eligible African American vineyard members, Flowers versus Mississippi, finding the Batson violation where the state struck 5 of the 6, or 83% of the black prospective jurors. The state's race-conscious jury selection is confirmed by the fact that the state created, used, modified, and printed a spreadsheet for the jury selection, which listed each qualified prospective juror with race, race and sex column, which marked each juror as B or M, oh boy, or B or F, black and male, or black and female, or white and male, or white and female. What about the other races? What are you saying? Anyway, the names of every single black juror, and only the black jurors, was bolded. The state also engaged in disparate questioning of black jurors and struck black jurors while keeping similarly stated white jurors. For example, the state asked Mr. Curtis Reiser, a black prospective juror, "You're sitting in the case of a black man. Do you feel like you owe him any allegiance because of that?" Oh, God. And when Mr. Reiser answered no, the state continued to press. So in terms of race, there is not a problem for you in that somebody could potentially say you afterwards, "How could you do that to another black man?" On the same juror's questionnaire, the state handwrote, "Seems okay, only concern, age and race. Juror's son is age and race." Oh, God. See how this is absolutely disgusting by the state. It is. It's disgusting. The state's own notes clearly convey that the race was top mind among jury selection considerations. Boy. The state continued to invoke unfair racial biases throughout the trial. For instance, the state asserted that to nearly all white jurors that Mr. Broadnax sought out the crime scene because that's where the rich white folks live, used to rap lyrics as evidence that Mr. Broadnax was part of a black gang, and in closing arguments explicitly compared Mr. Broadnax, the worst kind of predator, and "we like to watch on Animal Planet." God almighty. Okay, y'all. Ugh. After a trial in which the state relied heavily on race-based strategies and stereotypes, Mr. Broadnax was convicted and sentenced to death by an nearly all-white jury. During the appeals process, the state argued that the spreadsheet was created in preparation for a Batson hearing a hearing that was held after the jury had been selected. Okay. Now, in denying Mr. Broadnax's relief on his previously filed federal habeas petitions, the Fifth Circuit explicitly relied on the state's assertion that it created the race and gender marked spreadsheet when preparing to defend its use of preemptory challenges in Broadnax versus Lumpkin. However, newly disclosed evidence confirms that the state misrepresented its timing and purpose for creating a race-marked spreadsheet in its appellate arguments. In January of 2025, the Dallas County District Attorney's Office allowed counsel for Mr. Broadnax for the first time to review its jury selection files from the trial of Demarion Cummings. The Cummings files included a chart of prospective jurors, which were both the same race and gender notations as seen on the jury selection chart for Mr. Broadnax. The Cummings case was tried by subsequently the same team of attorneys representing the state as in Mr. Broadnax's case. Mr. Cummings' trial took place less than 5 months after Mr. Broadnax's trial concluded in August of 2009. Okay, so notably in Cummings' case, there were no Batson objections, meaning the state had no need to prepare for a Batson hearing. Since there was no Batson hearing to prepare for in the Cummings case, yet the state still prepared a jury chart with the same race and gender focused notations, that this newly disclosed file undermines the state's prior assertion that it created the spreadsheet to disclose Mr. Broadnax's case to prepare for the Batson hearing. The newly disclosed file confirms that the state's markings of prospective jurors by race and gender was evidence of systematic race-based discrimination by the state during a jury selection proceedings. Prior to its disclosure of this new evidence, just directly contradicting the state's pretext reasons. Mr. Broadnax has petitioned the court for a writ of certiorari. Although the court denied the petition, both Justice Sotomayor and Justice Jackson dissented from the denial, saying that they would reverse the judgment. So with the Cummings file now confirming that the state's previous explanation for the spreadsheet identifying prospective jurors by race was not true, there is certainly a reasonable probability that 4 members of the court would consider the underlying issue sufficiently meritorious for the grant of the certiorari, as well as significant possibility of reversal in the lower court. Number 2. Petitioner will be irreparably harmed if the state is not granted. Well, of course he will. Irreparable harm is necessarily present in a capital case. Oh my God. Okay. Absent intervention from this court, Mr. Broadnax will be executed on April 30th, 2026, based on an erroneous theory that he was the shooter, without necessary findings justifying a death sentence, and without ever receiving a fair trial free of ambiguous this Batson violation. Such a situation undeniably constitutes irreparable injuries. Wow. In addition, this court must give a non-frivolous claims of constitutional error the careful attention that they deserve. Approving the execution of a defendant before his appeal is decided on the merits would clearly be improper. This consideration further warrants a stay of execution. After Texas Court of Criminal Appeals denied Mr. Broadnax's third and subsequent application on April 7th, 2026, Broadnax timely petitioned this court for writ of certiorari. Merits briefing will take place over the next 3 months. If this court grants a review, the court cannot give due consideration to Mr. Broadnax's claim if he is executed as scheduled on April 30th. Mr. Broadnax's petition raises serious constitutional violations that are at the odds with the court's proceedings. The court should grant the stay so that the issues may be properly evaluated before Mr. Broadnax is put to death. The balance of equities and public interest and justify a stay. The equities in this case strongly favor granting a stay. The equities in the death case will almost always favor the prisoner so long as he or she can show reasonable probability of success on the merits. In light of what is at stake, it would be preferable for the lower court's decision to be reviewed on its merits before the executions are carried out. While the states have an interest in enforcing criminal judgments obtained in accordance with the Constitution, the public equities would only suffer if convictions and capital sentences secured by constitutional violations are carried out without serious claims of each violation being duly assessed. Our duty to search for constitutional error with painstaking care is never more exacting than it is in a capital case. Mr. Broadnax has been on death row for more than 17 years, and an execution date had not been set until December of last year. The state will not be prejudiced by a short stay of execution while this court considers the merits of Mr. Broadnax's claim. On the other hand, the public interest will be served by the court ensuring that the states comply with the court's decision. Further, this court has recognized a Batson violation inflicts harm not only upon the parties, but also upon the excluded jurors and the entire community. Jury service preserves the democratic element of the law, and it guards the rights of the parties and ensures the continued acceptance of the laws by all the people. The public is harmed by the state's participations in the perpetration of individual groups, stereotyped, and in this inevitable loss of confidence in our judicial system that the state sentence discriminations in the courtroom engenders. Okay. The community at large stands to gain from the court's meaningful enforcement of the crucial constitutional safeguards afforded by Batson. When the balance against this limited delay requested by Mr. Broadnax, the benefits of the court's protection of Mr. Broadnax's rights pursuant to the 8th and 14th Amendment, combined with the irreversible nature of the death penalty, heavily tipped the equities in favor of a limited stay of execution for this court's review. The application for stay of execution should be granted. So this was Mr. Broadnax's appeal to this was his writ of notorious appeal to the Supreme Court, to please delay while they looked into what happened for the Batson. Okay, forget all of this. No, let me talk about this for a second. Sorry, guys. All right, get back over here where I was. Now, let's talk about this for just a second. Now, hearing all of that, I'm going to sit here and say, I do believe that there was a Batson problem here. I believe that they discriminated against those jurors. I do. Because when you hear the judge say, well, we put one back on, what the hell does that mean? They added one because it was a disproportionate, so they just put one black person on amongst 11 white people. Now, let me ask you this, Sprinkle, what do you think about that?
Hold on, I was muted. No, I agree 100%. I mean, there's so much going on here. And the fact, that his DNA wasn't even on the gun. Come on. Come on. It was not on the gun, on the trigger of the gun, the grip of the gun, nor on the victim's pockets. There was nothing.
Only his statement.
How do you convict somebody, especially nowadays without, well, I mean, DNA is different than it was that many years ago.
Right.
But I mean, his DNA wasn't even on the freaking weapon. Come on.
Now, I mean, I'm going to say this for one of the victim's mothers saying, oh, they just did this to stop him from being executed. It's just all made up, right? I understand her saying that because she's still upset that this guy who got the death penalty is still hanging around here, 17 years later. But when you're looking at the public perception or the public, we have to rely on the law. We all have to follow the law. We should all use the law equally. And it was not equally used in this case. It just wasn't. That voir dire listing of the jurors. And boy, that is just, I'm almost at a loss for words about how to describe how I feel about this because it is wrong every step of the way. It should not matter what their race is, what their gender is, when you're in a voir dire for a capital trial or any trial. Every person that shows up in a jury pool, they answer questions on a little thing they fill out. And one of the first things that happens, how they get dismissed, is because if they have a criminal record themselves, they get dismissed. Okay, so every one of the people that got far enough for them on this list to start striking them because of race and gender had no criminal anything. They were just upstanding citizens trying to do their duty and serve as a juror, period. And I don't understand why in the world the Supreme Court of the United States of America denied, and this was 2 days ago, they denied it. Just 2 days ago. Now, I'm going to show y'all this I hope I can show this. Hang on a minute. This is from, hang on, pull this up for you guys to hear it. I think it's right here. Okay, let me share my screen right quick. I hope we don't get a copyright issue. I'm going to try not to. I might have to put my little dots over it or something because, we don't want to have a problem. Just not going to do that. Okay, now, let me go over here and get it started. Now, this is going to be from the defender. So this is the defender, and this is his group. So here we go.
That's all that stands between James Broadnax and a lethal injection in Texas. Broadnax has been on death row for nearly half his life, convicted of a double murder of Stephen Swan and Matthew Butler in the Dallas suburbs in 2008. And now, his cousin and co-defendant says it was he, not Broadnax, who killed the two men. On March 11th, Cummings signed a sworn confession under penalty of perjury, admitting that he was the one who pulled the trigger. not Broadnax. That confession is backed by DNA.
Here we go.
Only Cummings' DNA was found on the murder weapon. Sherry Lynn Johnson, an expert on the interface of race and issues in criminal procedure, and the assistant director of the Cornell Death Penalty Project, called the jury selection issue.
I think it's helpful to look at how these issues are linked to each other. So the jury selection issue here is really extraordinary. The names of the Black jurors, and only the Black jurors, were bolded. Reasons were given that did not explain the strikes. Some things were said that were not true. This is very strong evidence all by itself. And then it turned out that the state said, oh, well,
hang on.
we just put those.
Now, look at that right there. You can see, because like this is the seats, this is where everybody was sitting, and there's their little notes, and there's where they're striking people out. That is horrific. All right. Wow.
Those names in bold because we were trying to prepare for a Batson motion for a claim that there was discrimination. It turns out that's not true. And the way that we know that that's not true is the recently discovered evidence that they bolded the names in the case of the co-defendant as well, even though there was no motion about discrimination in that case. So I think, I think Steve is right that the most powerful claim is constitutional claim is probably the jury selection, but it's important to notice that why did they do that? And I think the reason that they did that is wanted to use racially inflammatory information.
Okay, for fair use, we always have to stop and talk about it. And even though I worked in the district attorney's office in my prior years, I will tell you that I truly agree with what this lady saying here. Constitutionally, they absolutely discriminated against these people. I don't know how they can sit there and lie to everybody and say, oh, it was for a Batson hearing, when they did it in the other case too. Did they think nobody would ever see this? Well, apparently they did think nobody would ever see this, because now here it is. And on that fact itself, he needs a stay of execution while they investigate this. Okay, we'll keep listening.
In order to sway a jury, information that would be less attractive to Black jurors. I mean, I think there's several pieces to that. The use of rap lyrics, as though that really defines what a person wants as opposed to a form of art. That was something that would be more attractive to white jurors. The use of language like animal and monster, and saying that they went into neighborhoods where there were rich people, those sorts of things that were.
All right. Okay, you heard me read that. Rich white people. And then him saying the words, oh God, that is so inflammatory. It is just ridiculous that I cannot believe that those prosecutors stood there and said that. 17 years ago is no different than it is today about trigger words and improperly discussing potential defendants. Yes, they're defendants. That's right. Yes, they are accused, but they are innocent until proven guilty. That is the way that the United States of America works. But it sounds to me like in this case, that is not how it was working. They were finding and saying everything they could to inflame these jurors into, well, he must be a monster, right? So what do you think, Sprinkle?
Oh, I agree. It's just egregious. Everything that happened is just unbelievable. And I mean, we're on the final hours here, and they're already setting up for his execution. I mean, it's a matter of what, 6 hours now?
Yeah. It's 12:45 p.m. Central Standard Time in Texas. He is set to go to the chambers at 6 p.m. Central Standard Time in Texas. And they have run out of every type of stay that they've run out of options to get a stay. The only other thing they can do is if the governor calls in and says, well, wait,
I mean, that happens. You have a lot of things they call at the last minute, but that man would literally be laying in that bed.
Right.
If the governor calls. He's gonna be laying in that bed with the man standing next to him ready to insert that IV into him. I mean, I can't imagine. I just can't imagine. I mean, and like you say, I understand the family wanting justice. I get that. You want justice, but you want true justice. You want true justice. If there
Yes,
was
you
a
do.
question, if there was a question, if it was my family member, I would want to know 100% that that person was responsible. Whether or not it was the death penalty, life in prison, anything. I would want to know that that was the person that was 100% responsible. If there was a question about it, that would bother me for the rest of my life. Like, well, what about the real person who did it? I don't know. I couldn't live with that. I couldn't live with not knowing they were the ones that were 100% guilty for it.
Right. I mean, I don't, we understand the people who work in the Texas Department correct. That's just their jobs, right? We know that. And they are bound to do their job, no matter what that job is, if it's part of their job duties. And I would hate to be the person in the death chamber that actually did that job. All right. I don't know how I would sleep at night. But then to know that this is a possibility that he could earn a stay of execution while they investigated this Batson hearing discussion, and then nobody steps in to take a look at this. It's just an injustice in America all the way around. It just is. We're gonna let her keep talking. Hang on.
Argued in closing, those were designed to appeal to a white audience. And so they selected a jury that would hear this inflammatory evidence. He had one conviction for a marijuana possession. This is something that a jury that could look in an open-hearted, open-minded way would have said, how is this a person who's dangerous in the future? And that wasn't a jury that the prosecution wanted. And I also think, even with respect to the new evidence of innocence, the jury even then should have wondered whether James really was the shooter. And that's because, though he said in his statement that he was the shooter, he said that when he was extraordinarily compromised in his ability because of drug use and psychosis. And then the forensic evidence then did point to him not being the shooter. So all of those things to me are why the state wanted an all-white jury, and in fact struck every single black juror. Although the judge put one back on, they wanted it because they wanted a jury to decide his fate and his sentence, who was not sympathetic to how young he was, who could not see him for the person he was, who had an extraordinarily difficult life, didn't want that, wanted to instead inflame the jury by racial imagery. And that's really shameful. It's been long established that you're not supposed to use evidence that is more prejudicial than probative. That's not a new idea. The application of that idea to rap lyrics is relatively new. Some jurisdictions have recognized for quite some time that it's usually more prejudicial than probative. Texas was slower in doing that, and it's only recently recognized that in Texas state courts. I think there is a growing sentiment about that it falls within that general category of being more prejudicial than probative. That is, more likely to inflame wrong stereotypes and ideas than it is to actually contribute in a meaningful way to the jury's decision. The entire
Okay, we're gonna have to stop and talk about it again for fair use. I know y'all understand that, and I hate to keep repeating it, but the last thing we want is to be talking about something so important, and it is important to all of us, because if it is not a fair trial, then how do you put a man to death? I don't understand how anybody could be okay with that. But I have always been, the death penalty is for some people, right? It just is. If you've got a Charles Manson over here, that's a death penalty, right? If you've got somebody like, well, in my book, Letitia Stout should have gotten the death penalty, but that was not on the table for her, all right? This new guy, Tanner, I don't remember his last name. He starts with an H anyway, and the death of little Athena, he is right now. They're deciding whether he gets the death or life in prison without parole. He confessed to everything, So really, their trial is just about what sentence to give him. And the things I'm hearing is that in the trial, as I listen to it, he absolutely should get the death penalty, right? But this guy, um, no, I just don't. I don't know. There's just too much on the line about what really happened, and the fact that the prosecutor's office acted so egregiously is correct. Here we go. We'll listen some more.
Hey, hold on
It's
1 second.
yeah.
You
Go ahead.
you want to know what's super ironic?
What's that?
Today is the 40th anniversary of Batson.
Oh,
Today.
wow. Today, and
Yeah.
they're still
Yeah.
not looking at it. Wow.
Yeah, it's the
It's
40th anniversary day. So are they trying to make some kind of statement like fuck the Batson by
I
having him
don't know.
executed today? Like
I don't
that's
know,
just
but
a little bit ironic for him to be executed on the 40th anniversary of that. Come on. How does that happen?
I'm trying to look and see if he was ever diagnosed with any type of psychological disorder. Was he depressed? Did he have what was his mental diagnosis? That's what we're going to look up really quick before I turn this back on. Let me take a look and see if we can find anything. Whoops. Okay.
I mean, he was never, like she said, he was never in trouble.
A marijuana charge, and that's nothing. It wasn't with intent to sell, you know. So
Mm-mm.
I don't understand why. I mean, it just seems so outrageous. Oh, come on, stop it. My phone is going crazy over here while I'm trying to look this up. It's putting all kinds of everything you can imagine just popping up in front of what I'm trying to look up. Okay, come on. Hang on a minute. I'm not saying mental illness is ever a reason, but if there's some kind of diagnosis that should have been looked at and was not looked at, then it matters. It absolutely matters. Okay. Well, I'm not finding. Sprinkle, see if you can find anything while I let this play, because I'm not finding anything about any type of mental diagnosis.
It just says James Garfield Broadnax was convicted of capital murder. ... Price admitted he was not making a mental health evaluation of Broadnax.
Okay. All right.
It says they denied any mental health problems according to testimony.
So in the 17 years that he's been in prison, he's never been talked to or had any type of diagnosis of a mental illness, period. I find that hard to
It
believe.
says in jail, Broadnax reported having hallucinations and delusions, but at times denied any mental health problems, according to testimony. Broadnax was treated with multiple medications for mental health issues, but Broadnax's medical records also indicate a notation that he could have been faking.
Oh, malingering? Okay. All right.
Yeah, I see blood coming out of the walls, just psychiatrist Franklin said. Broadnax reported not long after he was arrested, but he was coming off PCP too. So, I mean,
yeah, he might have been having that hallucinations. Yeah. All right.
Lane said at his last examination in June, I don't know what year this was, Broadnax no longer reported having hallucinations or delusions.
Okay.
Prosecutors suggested Broadnax may have been faking. They played a recorded phone call from jail where he feigned chest pains to leave his cell. I just wanted to get out of my cell and walk around a little bit. I told him my chest was hurting, he said.
Okay. Let's let her keep talking. We'll keep looking some things up here. It's just shameful.
Trial
here.
process is designed to prevent wrongful convictions. It doesn't always do that. I mean, there's a long history of exonerations, particularly in death penalty cases. I think there's a reason that there's more frequently error in death penalty cases than in other cases, because it's harder to get a death sentence, which means that there's more likely to be cheating to get a death sentence. And I do think that trying to sway the composition of the jury is one form of cheating. So, there's law that does forbid that. There's clear law that discrimination in jury selection is not permissible, that offers the right to have 12 people decide not only your guilt, but also your sentence. But that's often ignored. And I think that I've litigated such a case myself. That's Flowers versus Mississippi. And it took a very long time, 20 years on death row, before he was ultimately his conviction was reversed and he ultimately was exonerated. And unfortunately, that's not as uncommon as you would hope. So, there are some protections. Certainly our whole system is supposed to do that, but they're imperfect. And that's one of the reasons, of course, for clemency, as well as for judicial processes, because when the judicial processes fail, it falls to the governor and to the poll.
Okay, hold on a second. We'll stop again for fair use. But she's talking about clemency. Okay, if you want to participate in the poll that I've created, all you have to do is pick the number and type it into the chat box, and it will put it to the correct. It'll put it into the poll, and that's all you have to do. I put in number 3 because I think it depends on the crime, and it went ahead. That's great. I didn't realize it worked that way. See, I learn something new every day. But as we talk about clemency and how important it is for clemency to happen when juries get it wrong, or when there was something so egregious as this. So there's clemency and then there's pardon, right? Which are two complete different things. So clemency, it just means is the act of showing mercy, compassion, or leniency by an authority figure like a governor or president towards someone convicted of a crime, often resulting in reduced punishment, such as a pardon or commutation of a sentence. It is used to ensure fairness, acknowledge rehabilitation, or reduce severe penalties. So, the examples of clemency would be the governor granted clemency to a prisoner, requesting the defendant beg the judge for clemency before the sentencing. You've heard people say, I'm going to throw myself on the mercy of the court. Okay, they're begging for clemency. Or formal, literal, the sailor's hope for clemency from a storm. Okay, that has nothing to do with legal world anyway. So, and as far as pardon goes, but see, even a pardon is different from exoneration. So let's look at pardon, and then we'll look at exoneration. Whoops. Okay, because all of these are things that can happen in a trial. Come on, or to a prisoner who's already been. Okay, let's see. For full meaning of pardon, to absolve from the consequences of a fault or a crime, to allow an offense to pass without punishment, forgive, or to relieve a penalty improperly assessed. Okay, now let's compare pardon. We'll compare pardon to exoneration because they're two different things. People might not understand that. So here we go. All right, so here we go. A pardon is an act of an executive clemency by a president or governor that forgives the conviction, restoring the rights without erasing the record. Exoneration, on the other hand, conversely, is a legal finding that a person is actually innocent, usually vacating the conviction entirely. A pardon does not imply innocence, while exoneration proves innocence. Exoneration proves that the person is not going to ever have a record that they were guilty of anything. So it is so important in the state of Texas, if you are innocent, to get an exoneration. I know I talk about this a lot because it has a lot to do with when you have been put in prison for many, many years and you are actually innocent. Even if you get a pardon, your life is never going to be made whole. But if you get an exoneration, you do have the ability to file suit against the state of Texas and be made whole by some kind of money, because let's face it, after 20 years in prison, are these people going to go out and get a job? Are they going to go to school? What are they going to do? How are they going to live? What are they going to do? They're just going to go back and do more crimes? No, they don't want to do that. So this is the only way in Texas you can be completely relieved, found innocent, and get back to your life is by exoneration. It's so important for people to understand that. Here we go. Let's listen to the rest. Well, she's an attorney. It makes me, I really like her.
Board to do what is right. And I might add, that's true even if there's only doubt about what is right. You can sort of say, well, will we ever be 100% sure that James was not the shooter? I don't think it's possible to be 100% sure. But the evidence now, the combination of what the co-defendant said happened, and the fact that when James admitted to being the shooter, he was in a condition where he would not have known what he'd done, and the forensic evidence leaves enormous doubt at the very best as to who was the shooter. And that kind of doubt, one would hope, would lead to a clemency decision, if not actually relief in the courts.
And yet, inside those walls, life goes on. Just days after his legal team filed an emergency petition for a new trial, Broadnax was preparing to marry his fiancée, Tiana Krasnicki, a UK-based lawyer who first came to know him while researching American death penalty cases at the very prison where he is held.
So I met James through the time after I finished my first law degree, which was in England. I'm not sure if it's in America. Would it be the equivalent to that? To us,
it's different. We have a different system. Yeah.
Yeah. So I finished the first part of the law degree, and then I went to do my master's degree, which was the international human rights degree. And I met James. I contacted him because my paper was actually supposed to be on disparities on racial disparities and the death row in Texas. I contacted him, and it went from there, really. At first, I always tell everybody this: it was never the intention to be in a relationship with somebody on death row. It was purely something that was very platonic, very much the most be at friends. And yeah, so that's how we met. Our wedding keeps being pushed. It's not easy to get married to somebody in a Texas criminal justice system, but we're hoping to get married. Yeah, so it's been a lot. It has been a lot of working hard to ensure that James gets his justice, really, in a way, in terms of, obviously, with the new discovery. That's incredible, because I've always believed in James. I've always known that James, and obviously I guess that,
let's start. She's saying this new discovery. Well, I don't know that that's a new discovery just because his co-defendant changed, says he felt guilty, so he decided he would take responsibility for it, saying that he was actually the shooter. And yes, we know the DNA was there on the gun and on the person from the Mr. Cummings, which is the co-defendant. We know that. But I just see now. Then I have to question this as well. Now, and hear me out before you start saying anything. I know, because you're going, "What do you mean you got here?" There is always the possibility that one could have shot one and one took the gun and one shot the other. We don't know. We weren't there. We're never going to really know. We don't know if Mr. Cummings is saying this because he truly feels guilty, because he's found God in prison and he wants to make it right, or if he's saying this because this is his friend. They were longtime friends, and he doesn't want his friend to die when they were both in the same crime. I mean, it's just a hard.
Aren't they cousins? Aren't they? I think
yeah,
they're
cousins. They're cousins, right? So wouldn't you do the same thing? I don't know. I mean, I can't think criminally like that, but I don't know. Sprinkle, what do you think?
I agree. I mean, maybe he's just trying to tell the truth. You know, it could be just as simple as that. He's just telling the truth. Period.
Yeah, I mean, could be. Who would wait till who waits 17 years until they realize all this? Well, maybe because he said it as soon as he realized his cousin had a death date. When he realized, because the other attorney went to him and visited him and said, "Hey, listen, they're going to put your cousin to death on," and boy, that's just grabbing at your heart there. I mean, he's like,
oh yeah,
yeah,
that would get you. Right.
I mean, we know these people sit on death row for years and years and years, and some people think they're never going to get a death date. And so maybe at that point, I don't know. It's hard to decide.
Yeah, and 17 years on death row is not a lot of time.
No,
I mean, 17 years is a long time, but not to be on death row.
Most of them are 25 to 30 years.
Yeah, let's Google average time on death row.
All right. You know, look, Darlie Routier, she's another one. Hang on a minute.
He's in Texas.
Mm-hmm.
In Texas. It says inmates in Texas spend an average of approximately 11 to 11.22 years on death row. That's surprising.
That is surprising, because most of them is longer than that. Now let's
David
talk about
Lee Powell served over 31 years Joe Gonzalez was 252 days. Executed offenders are typically around 39 years of age. So it must
Wow.
be lower in Texas.
Well, we're going to talk about Darlie Routier for a moment. Now, she has not been put to death. She has no scheduled execution date. She remains on death row in Texas, where she has been incarcerated since 1997. Folks, it's 2026. Is that 29 years? Almost 30 years? Her offense date
Yeah.
was June of 1996, and she still has no death date. So I can imagine Mr. Cummings panicking when they comes in there and says, "Oh, hey, listen, we got a death date for your cousin, blah blah." So
Well,
I don't know,
they can't set a death date until all the appeals have been um
right?
ran through, right?
That's right. So I mean, his last ditch effort after getting a death date was his renunciatory that he submitted to the
Hmm.
Supreme Court of the United States. So let's listen to what his. I don't know if they're married yet, but it's interesting that she is from the UK and is an attorney herself in human rights and is marrying Mr. James Broadnax. That's amazing. Let's listen.
So Darlie Routier, she was incarcerated. Well, the murders happened in 1996. She's
Mm-hmm.
been in prison since 1997.
Right?
So damn near 30 years.
Damn near 30 years. All right. We're going
Hmm.
to listen to his wife speak some more. This is just a little bit longer. I'm sorry, guys. But I think it's interesting when you start hearing all the different stories.
The benefit of me being able to have, I even had the death penalty training with Amicus, so I was very much knowledgeable on the legal side of stuff because I'd been studying it, reading books. Obviously you get in a way you get trained in law school how to read case law and how to identify errors in trials. So I was able to use that knowledge and also being in a personal relationship with James to identify. And I've always believed that James was never the shooter because it correlates with obviously the DNA and every look. My easiest thing is if somebody is guilty in a court, you don't have to manipulate a courtroom in order to find somebody of guilt. So generally, if somebody is guilty, it's an easy thing. You've got DNA, you've got everything, which is easy, and you can just put it out there to the jury. But I always believed in James. I always pushed for James, and yeah, it's not been the easiest journey, but I will continue doing what I'm doing in order to make sure that what I know to do, and the abilities that I have to ensure that James gets his day of execution. But it's not easy being with somebody who has an execution date in a way you kind of want to value every single day that you have with each other. It does really emphasize in ensuring that you spend every day nice, like in a nice, very peaceful way, smiling, laughing. Obviously, we still haven't got it yet. The day of execution, we're hoping to do so. Like I said, I was able to have the benefit of knowing the legal case quite well and being able to read through it and understand all the legal jargon that not many people understand. But it has given me a lot of hope. It has pushed me even harder to be able to have a voice for James. And I like to be humble about it all because obviously it's still a case, there's unfortunate events in the case, but I humbly like to say that I am looking forward to knowing that there's a high possibility that I will be spending more time with James in the future rather than being timed. Being timed with life. I used to have a day count in how many more days I have. But I've had to turn that off because it was mentally really hurting me and James.
At sentencing, prosecutors read pages of broad.
She's absolutely correct. If a person is guilty, you do not have to manipulate to find them guilty. And when you have a Batson problem with with your jurors, you have manipulated the system to find him guilty. Now, I'm just going to say that because from what I read, that is what I see, and I do I like her, but I think she. I mean, she understands that he's never going to get out of prison. She knows that, right? But she has this desire for the human rights of everybody, and I think that her desire to help him just I think it's great, but I don't know that I would actually marry him. But that's just none of my business, right? That's between them, and I'm gonna stay out of it. But I think it's interesting her take on the whole situation. But we'll let this keep playing because I think the story's pretty good. It's pretty good.
Broadnax's rap lyrics allowed, arguing they proved he was dangerous. A number of prominent rap artists, including Travis Scott, Young Thug, and Killer Mike, are asking the U.S. Supreme Court to pause the death row execution next month. They filed amicus briefs at the court on Broadnax's behalf. Legal experts echoed that. Using rap lyrics to determine future dangerousness, one expert argued, is a First Amendment violation, weaponizing artistic expression against the very person who created it.
So we know that that lyrics, right, have been used in criminal court cases to prove violence, right? But these same lyrics that promote violence in different genres are not likely used in criminal proceedings. It's usually rap lyrics that end up being used in criminal court cases. And also, Texas is the most, we know that it has the highest death penalty rates, people on death row. It remains the leading execution state throughout the United States. So with the rap lyrics, as I was stating, what has evolved is questions of rights of freedom of speech. What we know is that rap lyrics have been used in court, right, in judicial processing to say, yes, that people that listen to this are more prone to violence, right? But what's interesting is that those same lyrics that are in different genres, it could be rock, hard metal, country, whatever, are not used in these criminal court processings and looked at as this person will be more violent in the future. So this questions, who really has the freedom of speech, right?
The clock is ticking. It is yet to be seen how the case unfolds.
All right, now let's talk about this for a second. Now, there's another case right now where people say, oh, he's dark. Well, he told us in his songs he was going to do this. And we're talking about the guy, David Berg, who is responsible for taking the life of Celeste. Well, he's been charged with taking the life of Celeste. I think her last name is Rivas. The same thing is being said about him. Well, did you listen to his music? Oh my gosh, everything is dark. He talks about killing. Oh, he had coffins in his music videos. It's the same thing. They're already, even though I feel like he probably did do this act. I'm not saying he did it because of his music or his lyrics. I'm not saying that at all. I'm saying he did it because, well, the evidence is kind of looking that way. But you have people who are already using his talent, his lyrics, his music to go ahead and say he's guilty. I mean, that's the reason why, because he wanted to know what it was like to take somebody's life. He sang about it. I mean, if you go and you listen to some of these things on YouTube, you're going to see where people are already saying these things, with him never even going to court yet. But anyway, I mean, it's kind of interesting that they're talking about these lyrics 17 years ago and today. Go ahead, Sprinkle.
Can you hear me?
Yeah, I can hear you. Mm-hmm.
Okay, my earbuds went out again. I don't know what's going on. No, I know you can't use music as evidence. That just sounds preposterous. Like, how could you use music as evidence? Like, that's just stupid. There's just no other words for that.
I agree. I mean, but when you have 17 years ago, let's talk about this for a minute. 17 years ago, when you have nearly an all-white jury that does not listen to what's considered rap music, right? Okay. Hey there, good to see you. Thank you for coming in. It's identifiable salute. 1298. Good to see you. Go ahead and answer our poll question if you would like to. Okay, you got to turn off your mic. You got to turn off your earbuds. Okay, it's there. Turn them off.
I haven't done anything. Let me put them away.
Okay, hang on a second.
Yeah, I'm gonna have to. I need to get new earbuds. I don't know what's wrong with these.
Yeah. Well, just mute yourself for a second. and then we'll come back. Okay. So what I was going to say is go ahead and answer our poll question. The poll question is, should all parties in a crime get the same punishment? And just put either number 1 for yes, a number 2 for no, or number 3 for it depends on the type of crime. If you just put the number in the chat box, it automatically puts it into the poll. Makes it super easy. But so what I was talking about is if you have somebody that was 17 years ago, a nearly all white jury, and they start discussing rap music and the meaning of rap music and etc., you're going to have a group of people that pretty much, I'm going to say, in the county that he was, his court, when his trial was held in, listen to country and western music. Okay, so when they start talking about rap music, these people are like, oh God, yeah, listen to that. I mean, I can see where there's just a lot of things wrong with that trial. I know he participated in this because in the robbery, and I know that somebody died in the robbery. And we do know that in Texas, that means you're eligible to go for the death sentence. It's just, that's the law, that's the rules. But let's go back now and listen to his own. There's another part of this interview where he is talking. So we're going to go find that, and we're going to let him. We're going to let his. Oh look, there's the happy couple right there. There they are. He looks so young. I mean, wow. Let me go up here. Hang on a minute. We're going to show this other. Oh, where did it go? I want to find the first part of this. There is a part of this where he is actually talking. So more videos. Here we go. Let's see. No, not none of those. Let's see. Maybe it's not over here on this one. All right. Let me see if it's right here. Hang on a second. So I'm gonna take this one off, and we're gonna add our other one. We're gonna share this page over here. Hang on a second. Oops. There is a video where he's talking, and that's really what I want to show. I found it earlier. Let me see if it's this one. Hang on a second, guys. Oh yeah. So let me share my page. Hang on a second. We're gonna share a page. All right. Well, let's get him up here. Let him speak. Oh, come on, thing. Stop doing that. Okay. Share your page. I think it's this one right here. It is this one. All right, share, and we're going to listen to him for just a second. All right, guys, here we go. Okay, here we go. This is an update. Skip the ad. Hang on there. Okay. Oh, that's not him talking. It's the other guy talking. All right. Well, we have that. I want to find where he's there. There's a video where he's at. Oh, here it is. Here we go. Here we go. Okay, let me get this going. Here we go. Okay, I found it. Let me share the screen with this one instead. Here we go. Share the stuff, and then we'll share the screen. It's interesting to listen to them give some kind of account. Here we go. All right. Now, this is going to be courtesy of Justice for James Broadnax. Here we go. Oh, I got to turn it on, stupid. Sorry, guys.
From where we lived in the projects in Texarkana. One particular day, me and some of my friends, we were coming into the cafeteria. It was an older guy in the cafeteria that I seen him drawing. So went up to see what he was doing. Hey, what you drawing? He started speaking to us, and he was telling us he's going to school for engineering and to hopefully be an architect. I'm like, architect. So I'm looking. So basically what he was doing was mapping out blueprints for something, a project that he was working to scale. And it looked super cool to me. And I'm like, man, I'm like seeing artwork, I'm into drawing, this sort of thing. But what he's doing and what he's telling me about it is
that's bad. I wonder why.
It pulled me in, it just caught my attention. So at that moment, it just sparked something in me where I'm like, man, I want to be an architect. I want to do what he does. When I was younger, school was, it became an escape to get away from home. I looked forward to going to school. I love learning science, all of that. So, but later it got to the point where I started losing interest. I began to kind of transition into this purely survival phase, because not just the toxicity of being abused physically and all of that. It's I'm pretty much being starved. So now I got to kind of find a way, figure out how I'm going to eat on my own. If I can't go to my friend's house and maybe eat with them for a day, then how I'm going to get money for, so it's like a lot of those little things built up into a bigger problem of how am I going to survive? So started losing focus, started skipping school, grades started dropping. A lot of things that I was passionate about, wanted to be an architect, wanted to get into engineering, do underwater welding, and
Oh, it
all of
sounds
these
bad.
things. It
Okay,
was
hang
just
on.
like, you know what?
All right.
That's a dream that's not
All
gonna
right,
be
hang on.
realized in my life.
Now, we are having a lot of thundering and lightning out there, and so my partner's saying that the sound is bad. Let me check and see what's going on with the sound. But we'll just talk for a minute while I do that. When you listen to him talk, this is the struggles of people, these young kids back in the projects whose families had a lot of kids, not a lot of money, and they're like 16, 15, 16, 17 years old. And I can see him out there hustling on his own. I can. And when these and I'm not making an excuse for him, but you've seen this before. They will have like the mind of maybe a 14 or 13-year-old. They're not really grown up, but they're trying to act grown up, sort of. So let me see if this is, let me check this out, guys. Hang on. I see it's kind of, oh, I see, because having a little bit of a problem with, oh no, don't do that. All right, hang on. I think I know what it is. Okay. What's happening is um, our internet is being affected by thunder and lightning and that kind of thing, so it might skip or stop every once in a while, but it will come back. So let's finish listening. Thank you guys for your patience. I really appreciate it.
Because right now I got too much going on and I can't commit time to. So you know what? Just forget it, type of thing. A few weeks before this case happened, I talked to an army recruiter. I don't even remember like exactly where I met him, but where one of my relatives was living at the time, we ended up having a meeting, and he came to speak to me, and he was explaining the process of, okay, this is what you would need to do. This is how you will get in it. If you accept it, you go into basic training. However, doing all of that, if you can commit to this 3-6 month process and doing that, you say you want to go back to school, the Army can help you with that. You want an education, the Army can help you with that. You're talking about resources, opportunity, and it's like everything this guy was saying. I'm like, man, where you been all my life? Like this is what I need, this is what I'm looking for, type of thing. But it was like, again, I'm 1 foot in, 1 foot out. I wasn't focused. I was too undecided on too many things. And it was like, okay, yeah, I want to commit to the time, but right now I'm not as disciplined as I should be. And I'm pretty sure I won't be able to do that. But I did have a real interest in wanting to do it. And it's something I was considering heavily. But not be on death row. I would not be in prison. I think in a very different way. I would have a family. I would have something solid, and not just career, just a foundation to fall back on. I think a lot of the principles and character traits that I had now, it could have been developed a hell of a lot earlier. Would have been able to get my education, like what I really wanted to do. Got into a good career field, being able to be a more productive citizen of society, being able to support and benefit my country as well. That whole thing with being a patriot. But just overall, I think my life would have turned out completely different. Yes. That has been something I regretted over the years, not taking the opportunity to enlist in the Army. Growing up, it's pretty well documented that I had a pretty traumatic childhood. I dealt with depression, throughout like the younger years of my life, going into my teenage years, and I felt that if I could numb myself from that, not think about it so much, or figure out a way to kind of like how can I say, take that part of your life, lock it away in your brain, so it's just suppressing it really. In doing that and not focusing on it, not having to talk about it, doing a thing like that, then maybe I can move forward in a different way in my life and get past it and act like it never happened, type of thing. So just being vulnerable and speaking about that, like not only is it painful, it creates problems in your life. But the older I got, especially since being here, I realized that that's worse than actually confronting your problems, right? So that's why like I'm much more open to talking about it now, because it's not only is it my story and I've had to find my own way of healing and you know figuring out the therapy side of that, right? In overcoming, but in facing it and dealing with it and confronting it for what it is, I've a lot of that has actually been some of the staples that's been able to allow me to help other guys around me, whether that's mentoring, whether that's just being a friend, being a brother.
Okay, we still have, even though it's the people fighting for his life's channel, we still have to do fair use. And so I'm going to say this: it sounds to me like he has taken advantage of therapies in prison, unlike other people do, and it helped him understand what happened, where he came from, and how he possibly ended up in that situation. And I think that's great. I do think that he is one of these people that his sentence should be commuted to life, period. Just like Mr. Cummings. That's what I think should happen here. Because I do see, but for me, it's because if I saw the manipulation in the board, that is the main reason. That is the reason why I think it needs to be commuted. But, I don't get to make decisions. But I think he's understanding exactly how, when, and where he made the mistakes that got him to where he was, and that he understands he could have done something different. And I think it's a shame that he didn't go to the Army, because we know of other people in situations, and they have admitted, well, I had to either go to the service or they were going to charge me for this, and they went to the service. So it's too bad that didn't get to happen for him, because I think he'd have been a whole different person. What do you think, Sprinkle?
Oh, absolutely. I mean, again, most of these people that commit these crimes at these age have a terrible childhood. They need structure. They need all the things that they weren't receiving at home. And if they were to receive all of those things, their life could have taken a different trajectory.
That's what I see in him. Which okay, that has nothing to do with it. Which I'm sure there's probably a lot of them in that prison, but a lot of them don't take advantage of the therapy to understand the background and how they ended up where they were. A lot of them just continually blame their parents and never take responsibility for any of it. So I think it's interesting that
I
he
mean,
is.
and at this point, he's damn near been in jail. He was 19 when he went in. He's been there
Right,
17 years. He's been in there almost half his life.
right.
Like literally almost half his life.
Had he not been 17, if he would have been 16, they might have tried him not as an adult. I'm not sure. But Texas is really harsh about taking these 16, 17-year-old people and
I
trying them as
I think
adults.
I think he was 19 when the crime happened, and he's been
Okay.
in there for 17 years.
Okay.
Yeah.
Yeah.
So anybody's a different person at 19 than they are at 37.
Oh, that's true.
You
That's true.
know, you
Right.
you grow, change, you become. 19-year-old boys, they think they're grown, they think they're men, but they're not. They're
Right.
just
They're
not.
not.
They're not. Some men aren't men at 37. But for the most part, once you pass 30, 35, 40, you become into your own and you become a man. He's definitely turned into a man now. And unfortunately, things that happened when he was 19, they can't be erased. No, they can't be erased.
Right.
But he's entitled to the same fairness and the same legal avenues that everyone else is entitled to.
Right. Okay, we're going to keep listening to him talking. I just want to stop for fair use. But I'm glad somebody gave him a chance to even, get an interview to tell his side. So.
And being open about that, because I understand and recognize my struggle, and I know what comes with the pain of that. So that's where it started. Humbling myself, surrendering, and committing to like real change, fundamentally across the board. Um, yeah, so I get here, and over the time, I've self-educated. I participated in a lot of personal development, fundamental redemptive courses, right? Of what they gave us access to with the faith-based programming and stuff like that. But even before then, you're talking about 12, 13 years before then, I self-educated. I was already participating in mentor programming, reading, studying, focusing on like what's inside of me that I need to change and develop to become that person that I have a vision for, right? Or like who I've been called to be. If you can change your mindset, you can effectively change your life. Period. It can happen. You just have to believe and you need to commit to the process. The lessons that I've learned, the wisdom that I've gained, the classes that I participated in, graduated from, that all of that, in addition to different friendships and relationships that I've built over the years, a lot of that is what goes into me being passionate about pouring into other guys around me, right? If I can be available to them, specifically guys around here mentoring and being a sort of like a big brother type of thing, because I know what the process of that changed in my life and what it helped develop me into. And it's just I would like to reach back and give that to other guys if they're pursuing the same thing. We were able to get a green light from the warden when it comes like to the mentor program, the peer-to-peer program mentorship that we were working on. One of the officers here, Stuckart, me and another brother, Tony Ford, we worked directly with him. He requested the help from us, but we worked directly with him to create this fundamental program of mentorship, this peer-to-peer program to give back to the guys that's in the facility. So yeah, that was a start. Not because of prison policies and them having shortage of staff at the moment and stuff like that. It hasn't been able to get up off the ground, but what we put together and everything that goes into that, it's already been greenlit and authorized by the top people in the administration, in what we were working to do. I do have a lot of friends now of like what started as like a pen pal effort. It has turned into like real friendships. And it's crazy that I've had friendships being on death row that lasted longer than friendships I had when I was free. Like, no kidding. It's crazy. I was just thinking about it the other day. One of my longest friendships, like since being here, is a couple friends overseas, and one of them has been for like almost 16 years now. It's crazy. So you don't see that a lot where I grew up, and people get disconnected and fall out for crazy reasons. But I've met people over the years, and again, like I have friendships now that has lasted over the years, and these people never asked nothing of me but just to be genuine and to give who I am, and it's been amazing. I've learned a lot through that. It's been some beautiful connections, and I think that's part of the beauty of this situation with having that level of exposure and meeting people from all walks of life all over the world that I probably would have never been exposed to, so, but yeah, it's been great. And a lot of them I see as family, not just friends, yeah. Tiana is
Okay, for fair use, we have to stop again, but I will be announcing this. Now, we saw his wife in the one video, or his soon-to-be wife in the one video, and actually, I'm going to tell you that they were actually able to get married on April 14th of 2026 over at the Allen B. Polanski unit in Livingston, Texas. So due to strict Texas prison regulations, the couple was separated by glass and could not touch or hold hands. So they at least got to get married before before the incident happens at 6 p.m. tonight. Unless the governor steps up, he will die by lethal injection at 6 p.m. Central Standard Time in Texas. We'll let him keep talking.
Tiana is my fiance. hopefully in the next few weeks, she will be my beautiful bride. She is amazing. She is a hell of a woman. Strong in character, personality, smart, intelligent. She's amazing. We have the same spiritual vision. We have the same vision for our family, what we believe in, the foundation for it, and everything. And I like to think that she is my twin in a lot of ways. She is absolutely my best friend. Um, Anything I could ever ask for in a life partner. A lot of people's, from what I've seen, now I'm only 37, but in my 37 years, a lot of people's perspective when it comes to relationship tends to be a little short-sighted to me, especially when you're just thinking about the physical aspect, because a relationship is so much more than that. I would say that's a factor. If you love a person like that with everything in you, of course you want to be together physically. Just something as simple as holding hands, hugging and kissing, and just that emotional connection of being available to each other. Of course, you want that. But when you're talking about a mental, emotional, and a spiritual connection with a person and finding somebody that completely, suits you, it's so much more, right? It's so much more um, sufficient, and it feeds you in a different way versus just being physically connected to somebody or thinking about a sexual aspect of a relationship. That's not what it's all about. Knowing somebody on a spiritual level, that emotional and that mental connectivity, that is to me what deepens your relationship and the bond, and it creates something that's like can be truly unbreakable. A big part of what I've reflected on in my life, it stemmed from that, you know, feeling like you were an outcast, you were thrown away, nobody loved you, nobody wanted you. And a lot of the problems in my life, it came from being in that mindset, or developing this mentality. But knowing that you are worthy of love, right? You are worthy of a relationship that's not toxic. Um, you can't have a healthy marriage just because you didn't grow up seeing that. It doesn't mean it's not possible for you. And it may sound pretty simplistic, but I do think it's that easy. Once you're exposed to that type of emotional connectivity, and the love and the bond, the commitment, the devotion of what you and that other person share, it can open up so many other avenues in your life just because you experience real love. Um, okay, so let's get creative. Um, all right, there's a poem that I wrote. It's actually a spoken. I write a lot of spoken word, but I like the traditional prose, haiku, different forms of poetry. But like spoken word is my favorite because to me, the structure of it relates more to like music and writing raps and stuff like that. So, but it's a spoken word that I wrote. It's called Realize, and it's spelled real eyes, like just a play on the word. And what it's speaking of, I let you be the judge of it. Okay. A voice that's non-mutable. Understand I've already passed. Sepulchral, soulful, so free when it bleeds. Life is elemental when it sways with the trees. Speaking past tense, don't coffin me because beauty is no less when it falls in the breeze. Life's only a dream within a dream. Everything the subconscious perceives as it seems. The truth is never hidden through a sky so serene. The spirit of the wind always weeps dead leaves. Truth.
Okay. All right. So here we go. That is the end of that. That was the end of his interview. So I think the whole situation. I don't know what's going to
It's
happen. Go ahead.
I just put in chat
I can't hear you.
GBT the difference between James
Okay.
and Darius Cummings. Because
Right.
can you hear me now?
Yeah, I can. Okay.
Can you hear me?
Yeah, I can hear you.
You can hear me now? Okay.
Yeah.
I put into I put into ChatGPT the difference between Darius Cummings and James Broadnax. Darius Cummings was the co-defendant. So according to ChatGPT, James got the death penalty because he was treated as the main killer as opposed to being an accomplice, and due to the violent nature of the crime. However, it was Darius's DNA that was found on the gun. So how can you create James as the main killer and give him the death penalty and give Darius the lesser sentence as an accomplice when his DNA was found on the weapon? It doesn't make sense to me.
No, it really
It
doesn't
doesn't
make
make
sense.
sense. Because I was trying to understand how come Darius got a lesser, a lesser sentence. And the only thing that I can find is because that they're saying that he was the main killer rather than the accomplice. But
Right.
how do you figure that? How did they figure that he was the main killer?
Because he made a
How did
statement that
they?
said he did.
But false confessions happen all the time. A confession shouldn't be I've always said a confession should match the evidence.
Right.
Period. And again, in so many cases, the confessions do not match the evidence. So we're just going by people's words nowadays. Rather, let's throw out DNA, let's throw out everything, and then just go by what people say. Do you know how fucked up a legal system that would be?
Yeah,
Because
I
that's
do.
what that's what they're doing.
Well,
It's like DNA means nothing in this. Nothing.
well, we know how DNA gets onto murder weapons and people. We know how it gets there. They have to touch it. It has to be their saliva. It has to be something from their body fluids that gets on the gun or on the person,
So,
etc. So how
by
can
some kind of
yeah,
transfer.
transfer? Right.
Yeah.
So if he never touched the gun and he never touched one of the people, although it was a robbery, we know that it was a robbery. That's such it's so questionable. But when you have the prosecutors manipulating the trial by what they did with the Batson situation, then what the jurors, because in most cases, and this is kind of a study that they've done, in most cases, if the prosecutors are looked at as always being honest, what are you saying? And then you've got the defense attorney who's just trying to use whatever he can to get the other person out of going to jail for the offense or out of getting capital punishment for the offense. So people tend to think that the prosecutors are always telling the truth because they are the prosecutor, which is kind of it's a biased situation when you're talking about trials. I mean, and even though they answer the questionnaire, no, I'm not biased either side. I just have to listen to the evidence. Deep in the back of their mind, I know that people think that the prosecutors are always honest. Period. So the only hope for Mr. Broadnax today between 1:44 and 6 p.m., which is literally just hours, is for Governor Abbott to step up and say, all right, listen, I'm going to stay this execution so we can look at the situation. But as of right now, there is no information being talked about. Governor Abbott is not nothing. There's just nothing being reported that he's even thinking about it. So I don't really know what's going to happen. Sadly, I do believe that this will be one of those cases where Texas may have got it wrong. And it will be after the fact that this will be discovered that Texas got it wrong. So we've been on for almost 2 hours. I just wanted to come and talk about this today because it's so important, because this happens this afternoon, and because I do feel like he had a case and he was not looked at. So, any last words, Sprinkle?
No, it's just heartbreaking because you want to hope that justice is going to prevail, whatever that is, true justice. And in so many of these cases, especially this one, it just doesn't seem like it's happening. And it makes you
Yeah.
wonder the reasons.
Let me see something. I'm going to look up something really quick before we go. How many innocent people have been put to death? Because I know there's others in Texas.
Yeah.
You know,
I mean, he's
that's what
definitely
it
not
says.
innocent. He's not innocent, but the punishment should fit the crime. The punishment should fit the crime.
So according to what I've looked up, confirmed widely cited examples of could have been wrongly executed are Carlos de Luna, Cameron Todd Willingham, and Tommy Lee Walker, officially exonerated in 2026 after execution.
Holy
Tommy
shit.
Lee Walker, yes, exonerated after posthumous exoneration is what that's called. So Texas has executed 597 people since 1982. 16 people from Texas have been exonerated from death row before execution. So how is he the only one? So confirmed post-execution instances, only one, and that's Mr. Tommy Lee Walker, who had already been put to death. So Texas does
Can you
get it
imagine?
wrong. No, I can't. I
God,
can't.
wow.
So yes, Texas has likely executed innocent people.
You know, you
And
have to look at
so,
these
go ahead.
you you have to look at these cases of what, okay, if this was your family member, how would you feel?
Hmm.
What would you want? Do you think it's fair? Do you think it's right? You have to look at it on the other side. Take the race out of it, take everything out of it, take the emotions out of it, take everything out of it, and look at the facts and look at what's happening. And so many of these cases, you look at them, and if they were your family member or your friend or your loved one, it just isn't right. I mean, right is right, wrong is wrong. And this definitely to me looks like wrong. Yeah, of course he needs to be in jail if he was involved in something like that. Two people lost their lives. Even though he was 19, it still doesn't take away from the crime. But to kill the man based on what? Come on.
Right. I mean, according to the experts, they estimate that 10 wrongful executions have happened in Texas, but all that's known of is Mr. Walker. And with that, we're going to leave today, and we'll just have to see what happens. I don't know. I don't know how anybody else feels about it, and I don't know if anybody else has all the same information that we've looked at today. But just from my opinion, based on what I see, Texas is about to be wrong. And I hope that Governor Abbott looks at the case and decides to give him a chance to look at the Dyer and the Batson situation because it is important. We all deserve justice to be fair and equal, period. Not based on sex, race, ethnicity, none of that. It needs to be equal. We're all equal. Treat all defendants equally. You are guilty, you are innocent until you are proven guilty. That is what we're led to believe, period. So with that, we're going to say, have a wonderful afternoon. Be careful out there. Take care of yourselves. And go ahead, Sprinkle.
And hug your babies.
That's right. See, our life is short, but our time with our
Hug your
babies is even
babies.
shorter. Because they grow up and then you become empty nesters and they get their own life. And there's so many things. There's so many regrets that people have later on in life, and you just don't want that to be you. You don't want that to be you. So with that, we're going to say goodnight, goodbye, and we're coming back on Monday to do a birthday party for Dee Dee Blanchard. That's right, for Dee Dee Blanchard, whose life was also taken by a person who says that she does not identify as a murderer, even though she planned the entire murder and she paid for it, planned it, brought the person to her home, and took advantage of a mentally challenged man who is now in prison for the rest of his life with no parole, and his name is Nick Godejohn. So think about that, people. Think about that. I'm going to say good night. Thanks again. Have a good afternoon. Bye, guys.